Very good, Chief. All those folks are up.
Thank you, Ms. Adams. So, ma'am, are you Miss Compierre?
No.
Tell me your name.
Diamond Mitchell.
Okay.
Yes, Miss Compier, Miss Compier bonded out.
I just saw it. Well, actually, I saw it earlier. Sorry, making a mess over here on my side. Ms. Mitchell, you've been charged with 1 count of aggravated assault, 1 count of battery, and 1 count of cruelty to children in the 1st degree. The bond is going to be denied at this point on the aggravated assault charge. I'm setting a bond of $5,000 each on the battery and cruelty to children in 1st degree. You're going to have a preliminary hearing date that's going to be set for April 19th at 8:30 in the morning.
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Now, how much do you make per hour? It's $10 an hour?
Yes.
Okay. I'm going to find that you qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. I'm going to also set a bond hearing date for April 16th. And that also will be 8:30 in the morning.
Yes, sir.
I'm sorry. April 23rd, not the 16th. Do you have any questions of me, ma'am?
No, sir.
Okay, you're free to go back.
Ms. Bedford?
Ms. Pettiford, you've been charged with 1 count of theft by deception. The bond is going to be set at $2,000 for that. Do you believe you can post that bond, ma'am?
Yes, sir.
Okay, you're going to have a preliminary hearing date that's going to be set for April 20th at 8:30 in the morning. And that's going to be by Zoom hearing like we're having here today. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir. I'll hire my own.
Okay. If you don't have any questions for me, ma'am, you're free to go back.
Thank you, sir.
Okay.
Williamson?
Ms. Williamson, you've been charged with 1 count of criminal trespass. The bond is going to be set at $3,000 for that. Do you believe you can post that bond, ma'am?
Yes, sir.
Okay, you're going to have a preliminary hearing date that's going to be set for April 20th at 8:30 in the morning. That hearing date will be waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir. I don't want a lawyer for this.
Okay, you're going to represent yourself?
Yes, sir.
Okay. If you don't have any questions of me, ma'am, you're free to go back.
I do. I have a total of $15,000 in my property. Am I able to bond myself out?
I believe so, ma'am, but that is a question that is best reserved for the sheriff's department personnel. They're the experts on it. Okay?
Your Honor.
Okay, you're free to go back.
Thank you.
Your Honor?
Yes.
I have, if it's possible, I need to, can I put Zachary in front of Woodruff? Because Woodruff is in a wheelchair.
Sure.
Come on, Zachary.
Okay, you're Ms. Zachary?
Yes, sir.
Ma'am, you charged with one count of obstructing an officer. The bond's gonna be set at $2,000 for that. Do you believe you can post that bond?
Yes, sir.
Okay. You're gonna have a preliminary hearing date that's gonna be set for April 20th at 8:30 in the morning. That date is gonna get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Ms. Zachary. I'm going to appoint a lawyer to represent you. Do you have any questions for me, ma'am?
No, sir. Thank you.
Okay, you're free to go back.
I'm trying to position this camera a little bit, Your Honor.
Okay. Ms. Woodruff, you've been charged with one count of simple battery.
Yes, sir.
The bond is going to be set at $5,000 for this, and there's going to be a stay away provision on the bond to stay away from Antoine Santos. He's going to have a stay away provision on his bond to stay away from you as well. Do you believe that you can post that bond now? I'm sorry?
Yes.
Okay. Do you understand stay away provision?
Yes.
Okay, you're going to have a preliminary hearing date also that's going to be set for April 20th, and that date will be waived upon your bonding out, and you'll receive a new date in the mail. Do you have any questions of me, ma'am?
No.
Okay, you're free to go back. Oh, I'm sorry, ma'am. Would you like for me to see if you qualify for the appointment of a lawyer? How much do you make per hour or per month? I'm trying to, I can't really understand what you wrote. Could you tell me how much do you make per month?
I work for Uber. I do $500 a week.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. And if you do not have any questions for me, you're free to go back.
All right. Have a great one.
You too.
That's all the females I have, Your Honor.
Thank you. Have a good day.
You as well.
Okay. All right, we're ready to start on the male side.
All right, we got Mr. Batt first.
You are Mr. Batten, correct?
Yes, sir.
Sir, you've been charged with one count of simple battery. You're going to have a $5,000 bond. There's going to be a stay away provision on the bond to stay away from Annie Batten. Do you believe you can post this bond?
Yes, sir. But that's my primary contact. I just got to try to memorize another phone number to contact.
Okay. I believe. Well, I generally tell people to try 411 as it relates to trying to find other people that you don't remember their number. But the Sheriff's Department also has a list of bonding companies that are authorized to write bonds here in Clayton County. And you can contact the bonding companies and ask for their assistance also. You're going to have a preliminary hearing date that's going to be set for April 20th at 8:30 in the morning. And that's going to be over a Zoom hearing like we're having here today. But that hearing date is going to get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. Yes.
Okay. You do qualify, Mr. Batten. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
The stay away provision, we have a shared responsibility of the daughter, and we take turns picking up and dropping off the daycare because we work different shifts. So I don't know how that works.
Well, so Ms. Batten can contact the Clayton County Solicitor's Office. And she can inform them that she is not afraid of you and that her desire is for this stay away provision to be lifted, and it can be lifted. At this stage, we put the stay away provision on because we don't want whatever situation caused you to come before me to flare back up once you bond out. So that's something where we don't know the circumstances, and you and Miss Batten best know the circumstances. So if that's something that she wants to do, she can do. But at this stage, you're to stay away from her until you receive notice otherwise, okay?
Yes, sir.
All right. Is there anything else, Mr. Batten?
No, sir.
Okay, you're free to go back.
Next is Mr. Timothy Brown. You can go back to the door. Don't let the door
Can't
close.
use the phone yet.
Not yet.
Okay, Mr. Brown, you've been charged with 5 different offenses. Let's see, improper lane change. Bond's gonna be set at $500. Driving without a license, the bond is gonna be set at $1,000. Tenant window violation, the bond is also set at $500. There's a theft by receiving stolen property count. And the bond is going to be set at $20,000 for that. And open container violation, bond's going to be set at $500. So that's going to be a total bond of $22,500. Do you believe you can post that bond?
Yes, sir.
Okay. You're going to have a preliminary hearing date that's going to be set for April 19th at 8:30 in the morning. That's more likely going to be over Zoom hearing like we're having here today. That date will get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
I hired one myself.
Okay. Do you have any questions of me, Mr. Brown?
I have one question for the suspended license charges. My license wasn't suspended. It's just that I didn't, it was out of date. It wasn't suspended at all.
Yeah, I'm sorry. If I said expended license, it was the charge was expired license.
Yes, it was expired, yes.
Yes, sir. So I apologize if I
So
said.
how much is that one?
It's the same for these. The minimum amount is 500. So as you notice, the improper lane change, no, I'm sorry, it's not 500. It's 1,000. The driving with no license is 1,000, and driving on expired license is 1,500.
I had a license.
So the charge is expired license,
Yes,
and it's $1,000.
okay.
Okay, and I apologize for confusing you. So do you plan on hiring your own lawyer? You said.
Yes, sir.
Okay. Do you have any other questions for me, Mr. Brown?
Can you repeat that, total, my total?
$22,500.
Thank you, sir.
Okay, you're free to go back.
All right.
All right, next is Mr. Chan.
Okay. Mr. Chan, you have 4 offenses. Your vehicle, it says it had no tag light. The bond for that is $500. There's driving on a suspended license. The bond is $1,500. There's a count of knowingly driving a vehicle with a suspended license, and the bond for that is $500. And driving a vehicle with no insurance, the bond is $1,000. So that's a total bond of $3,000. I'm sorry. of $3,500. Do you believe you can post that bond, sir?
Yes, sir.
Okay. You're going to have a preliminary hearing date that's going to be set for April 20th at 8:30 in the morning. That date will get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
You do qualify, Mr. Chan. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
Yes, yes, I want to be, like, get up from the, I want to go work, I want to get up from the jail, go work, I want to be bound, bound hour today, go back to work,
Are you asking, will you bond out today?
Yeah,
Yes, yes, sir. The way it works is that I complete this paperwork after this proceeding, and I send the paperwork back to the sheriff's department, and they begin to process it.
okay.
So when this hearing is over is when the clock really starts to tick. So I'll say it'll be probably 3 or 4 hours maybe before you're able to get out.
Yes, sir,
Okay?
okay,
Any other questions?
no bad.
Okay, you're free to go back.
Next is Mr. Clayton.
Mr. Creighton, you're charged with 1 count of obstructing an officer. I've set the bond at $1,500. Do you believe you can post that bond, sir?
Yes, sir.
You're going to have a preliminary hearing date set for April 20th at 8:30 in the morning. That date is going to get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, Mr. Creighton, so I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
No, sir.
Okay, you're free to go back.
Go back to the. Yes, sir. Next is Mr. D. Antonio.
Okay. Sir, you've been charged with 1 count of battery, 1 count of aggravated assault with a deadly weapon, 1 count of terrorist threats, and 1 count of public drunkenness. There's going to be $1,000 bond set on the public drunkenness charge, but the other charges are going to be, bond is going to be denied at this stage on those charges. We're going to have a preliminary hearing date set for April 19th at 8:30 in the morning. You're going to also have a bond hearing date set for April 23rd. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Dan Antonio, so I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Next is Mr. Garcia. Yeah, I'll let you know.
Mr. Garcia, you're charged with DUI as a second offense. The bond is going to be set at $10,000 for that. Parking in a prohibited space, bond is going to be set at $500, and driving a vehicle with an expired registration, bond is going to be set at $500. So you're going to have a total bond of $11,000. You believe you can post that bond, sir?
Yes, sir.
You're going to have a preliminary hearing date that's going to be set for April 20th at 8:30 in the morning. And that's going to be over Zoom hearing like we're having here today. Would you like for me to see if you qualify for the appointment of a lawyer? You're going to hire your own, you're going to represent yourself.
I'll get one myself.
Okay. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Thank you, sir.
You're welcome.
All right, next is Mr. Godby.
All right.
Good morning.
Good morning, Mr. Darby. You charged with 1 count of criminal trespass and 1 count of terroristic threats or acts. The terroristic threats or acts is a felony offense. So you're going to have a preliminary hearing date set for April 19th at 8:30 in the morning. And that's going to be a Zoom hearing today, like we're having here today. The total bond for both of these charges is going to be $8,000. Do you believe you can post that bond, sir?
No.
Okay. I would encourage you, Mr. Godby, to contact the bonding companies that are authorized to write bonds here. And they will work with you. You need not sit here in jail.
Yeah, because $8,000, that would be $4,000, right, sir? I had to come up with.
It'll be closer to 1,000 if you're going through a bonding company.
See, I got the money at the house, sir, but I didn't have my wallet or nothing, my cards or nothing, you know.
So I would encourage you, Mr. Godby, to either go through the bonding company or go through whomever you can to arrange to bring the money to the sheriff's department because you need not sit in jail.
Yeah, I understand, sir.
Yes. There's going to be a stay away provision on your bond to stay away from Trina Lewis.
All right, excuse me, sir. How can she put that on me and she live in my house where I pay rent at? And she's not gonna be able to pay the rent either.
Well, I wish that your situation was one that was really rare, but it's something that I see on a daily basis. And the only thing that I can do is I was a criminal defense lawyer for more than 20 years, and I would see this happen all the time. But it's like you gotta, you know.
I didn't do nothing to her. I just walked away from her, and she the one did all this stuff.
Well,
I lose my apartment because of her.
What I would encourage my clients to do would be to, you know, they need to move away from people. When I say move away, not move, but just stay away from people that are not, you know, they don't have your best interests at heart.
No.
So with this stay away provision, it can get lifted, but she would have to contact the solicitor's office and tell them that she wants this provision to be lifted. Okay.
It's either that or she gonna get thrown out because she don't have enough money to pay for that place. It's her choice.
Right. And I would just take this as a lesson that for you about whether this person should or should not be in your life.
You ain't got to worry about it. As soon as I get out of here, I'm gonna hit a truck and go.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Okay, you do qualify, Mr. Godby. I'm going to appoint a lawyer to represent you. Do you have any other questions of me, sir?
There's nothing that I can do right now because unless I can get in touch with the bailman because I can't get them the money until I can get out of here or whatever to go get my belongings. Because all my personal ID, I can't. They brought me to jail in my underwear.
You should make arrangements with the sheriff's department to go get your items until she tells the solicitor's office that she's not afraid of you and she wants this provision to be lifted because you don't want you to get felony charges.
Yes, sir. I understand.
Okay?
All right. Thank you.
You're free to go back.
All right.
All right, Your Honor, Mr. Hunsaker, he's a fugitive, so he's gonna go last.
Okay.
So we're gonna go to Mr. King. They give it to you, you ain't got.
Mr. King?
Yes, sir.
You're charged with 1 count of violation of Georgia Controlled Substance Act. Bond is going to be set at $5,000 for that. 1 count of giving a false name, address, or date of birth. bond is going to be set at $2,000, and 1 count of loitering, bond's going to be set at $1,000. So that's a total bond of $8,000. Do you believe you can post that bond?
That's fine, but, yeah, no, I'm saying like, well, not now, but I will be able to put bond in a minute.
Okay. You're going to have a preliminary hearing date that's going to be set for April 19th at 8:30 in the morning. That date is going to get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Sure.
You do qualify, Mr. King. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
No, so that'd be like, what, like 1,200 to a bonding company?
It may be less, and I always tell people that when I give you what I give you is only a guess. They're the ones that will tell you this is what we're going to charge. So I would go with what the bonding company tells you. Well, you're going to have to do that, but just you got an idea in mind. It may be less than 1,200, but you're going to have to call to find out.
Okay.
All right. Any other questions?
Sir, that's it.
Okay, you're free to go back.
Thank you.
Next is Mr. Mendoza. Go ahead.
It was Mendoza? Mendaka. Okay. I'm sorry, sir. You're charged with 1 count of discharging a firearm near a highway. The bond for that is set at $5,000. Do you believe you can post that bond?
I believe so, sir.
Okay. You're going to have a preliminary hearing date that's going to be set for April 20th at 8:30 in the morning. Let's see. It's going to be over Zoom call like we're having here today. Do you want me to see if you qualify for the appointment of a lawyer?
If you're able to check for that, does that mean I have to take it, or it's just so I know if I'm qualified?
Well, if I appoint the lawyer will have to take your case, but you can always fire the lawyer and hire your own lawyer or do whatever you want to do.
Okay. Well, I would like to know if I'm able to, if I'm eligible.
Okay. You do qualify. So what I'll do is I'll appoint a lawyer at this stage to represent you. If you decide that you're going to go a different route and hire your own lawyer, you're going to represent yourself, you just need to let the law firm know.
Prior to the date of the 20th?
Well, you have a right in this country to whatever lawyer you choose. So you can fire 20 different lawyers if that's what you want to do.
Okay.
But you just got to notify them. And the reason I say that is because they get these appointments every day. And so they need to know if you don't want their services. So they're not wasting their time.
Okay.
Okay. Any other questions?
No, sir.
All right. You're free to go back.
Thank you.
Okay, next is Mr. Middlebrook.
So Middlebrook, you're charged with possession of a firearm by a convicted felon, and it looks as though I cannot set you a bond on that felony offense at this point because there's an indication that you're still on probation. You're going to have a bond set at $500 on the window tint violation. I am going to set you a preliminary hearing date of April 19th at 8:30 in the morning. I'm also going to set a bond hearing date for April 16th. I'm sorry, April 23rd.
April 23rd?
Yes, sir.
Oh, I know I'm supposed to talk about my case, sir, but I got like a question. All right, I'm the head security guard at my, establishment that, we secure Escobar, South. And my coworker left his gun inside my car when I gave him a ride home. And I was going back to work. I was headed to work, dressed out in my, my uniform, and I got pulled over. Is there some type of leeway I could? I, it's almost like a catch-22. I know I don't supposed to have a firearm, but I was giving a coworker a ride, and he left it. It was no bullets up in there. The gun wasn't stolen. It was registered to him. Like,
So let me ask you this. Would you like for me to see if you qualify for the appointment of a lawyer?
yes.
Okay, you do qualify. I am going to appoint a lawyer to represent you. So with that being said, you need to tell the lawyer what you just told me, because that could amount to a defense to the charge. And it could be something that could lead to your charges being dismissed way before you get to those court dates that I mentioned. But you would need to speak to your coworker, and the coworker would have to write a statement related to that. But your lawyer is the person that could help you. Okay.
Thank you.
All right, you're free to go back.
Next is Walker. NWAKOR.
Okay. Sir, you're charged with failure to stop for they have improper stopping on the warrant. But the bond is going to be $500 for that charge. There is a violation of Georgia Controlled Substance Act, and violation, actually two. One is possession and one is possession with intent. Bond is going to be set at $5,000 for the possession and $10,000 for the possession with intent. You're going to have a total bond of $20,000. Do you believe you can post that bond?
Yes, sir.
Okay. You're going to have a preliminary hearing date that's going to be set for April 19th at 8:30 in the morning. That date is going to get waived upon your bonding out. Do you want me to see if you qualify for the appointment of a lawyer? Or are you going to represent yourself? Okay.
Yes, Your Honor.
All right. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Mr. Reginado, you know, we need him first. So the next is Santos.
Mr. Santos, you've been charged with one count of battery, one count of obstructing or hindering law enforcement, one count of giving a false name, address, date of birth, and one count of false imprisonment. You're going to have a total bond that's going to be set at $20,000. Do you believe you can post that bond?
That's $2,000. Yeah, I can post that.
Okay. You're going to also have a stay away provision to stay away from Crystal Woodruff. And I put a stay away provision on her bond to stay away from you. Yes, sir.
I got a question.
Yes, sir.
I want to know, and this don't really have nothing to do with my case. I just want to know, how am I charged? She has no marks on her, but she don't get strangulation, but I get held, you know, I get withholding her hostage, and we was all outside when this was happening. You see what I'm saying?
I understand what you're saying. This is your charges were brought by a Officer McCall, and so the officer went to a judge and swore to these facts. They don't mean that they actually happened. Because at this stage, everything is an allegation.
Yes, sir.
So that's what you're being accused of doing. They have to prove it beyond a reasonable doubt.
Okay.
So, you know, the old saying as it relates to district attorneys and grand juries is that they can indict a ham sandwich. Because the allegations are the allegations. So it's not that you did it or didn't do it.
Okay.
As a judge sitting in this proceeding, I have to look at both sides and see that both sides are true and just try to figure out bonds and court dates and that kind of thing. So would you like for me to see if you qualify for the appointment of a lawyer, or are you going to hire your own?
Yes, sir, you can.
Okay. You do qualify, Mr. Santos. I'm going to appoint a lawyer to represent you. Do you
So I
have
can find out today?
Yes, sir.
Okay.
Do you have any other questions of me?
No, sir, thank you.
Okay, you're free to go back.
All right, y'all, the next is Mr. Sims.
Mr. Sims, you have a number of charges. Fleeing from a police officer, bond's going to be $2,000. Reckless driving, bond's going to be $3,000. Speeding, bond's going to be $500. There is a red light violation, bond is going to be $500. For the aggravated assault on a police officer and obstructing an officer charge, I cannot set bond on those offenses because there's an indication that you're still on probation. And the way that that works is that it can't get set now, but it can get consented to by the district attorney. The purpose for this law is that people who are on probation or parole, because of how quickly you come before a judge, they wanted time to be able to assess the situation. So that's something that if you, when we get to the point of you wanting me to see, let me ask you, do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, Mr. Sims. I'm going to appoint a lawyer to represent you. Your lawyer can contact the district attorney's office or your probation officer and inquire as to whether they want to hold you. Probation officer. And if the probation officer says, no, I don't want to hold him, then your lawyer can get the state to consent to a bond on the two charges that I've denied bond on because it looks like you're on probation. The hit and run is going to be a $5,000 bond. The simple assault is going to be a $3,000 bond. There's a $1,500 bond for the marijuana charge, $500 bond for the improper lane change, and looks like the running a red light is going to be $500 bond. And striking a fixed object, the bond is set at $1,500. I'm going to give you a preliminary hearing date of April 19th at 8:30 in the morning, and that'll be over Zoom call like we're having here today. And I'm going to set a bond hearing for April 23rd at 8:30 in the morning. So if your lawyer is unsuccessful in getting a consent, you can still have a bond hearing. And at that time, bond can be set.
Okay, thank you, sir.
You're welcome. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Thank you.
You're welcome.
Next is Mr. Wani.
I didn't get a total.
Okay, Your Honor, Mr. Sims wants the total of his bond.
Okay. So the bonds that I was able to set bond, the total is 18,000.
All right, thank you, sir.
You're welcome.
Good morning, Your Honor.
Good morning. You're Mr. Wani?
Yeah,
Okay, sir, your charges are going to be dismissed. And they're being dismissed because of a technicality. Whenever there's a charge involving a victim, the police officers are supposed to name the victim. And in this case, or identify the victim. In this case, they did not identify the victim or his wife. And there was no way for me to identify the victim. So as a judge, I cannot approve those charges. It does not mean that these charges cannot be brought back, because it can. But at this stage, they're being dismissed. So when you're welcome. So when this paperwork gets to the sheriff's department, they'll process it and you'll be released.
yes.
Okay. Have a good day.
All right, next is Welch.
Okay, sir, you've been charged with 1 count of violation of Georgia Controlled Substance Act. The bond is going to be set at $5,000. Do you believe you can post that bond?
Yes, sir.
Okay. You're going to have a preliminary hearing date that's going to be set for April 19th at 8:30 in the morning. But that hearing date is going to get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Welch. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back.
All right, last is the fugitive, Mr. Hunter.
Okay. Sir, your hearing is a little bit different than the other people that I've dealt with.
Correct.
The same rights still apply to you as to them, but you are considered what's called a fugitive from justice, which basically means that there's another state that wants to bring you back based upon a warrant. And in your case, the warrant is from, looks like it says Utah County Sheriff's Department wants you, and the warrant is alleging larceny. So you have the right to a hearing to determine whether you are the correct person named in the warrant and whether the charges are actual charges. And that would be the only thing that the court here would be making a determination of. So we would not be making a determination as to whether you're guilty or innocent of the charges. Do you have a lawyer now representing you on these charges?
No, but I plan to hire one.
Okay. So, yes, sir. Okay, I'm sorry. So you can fight these charges, and you can say, I want a hearing. That hearing will be held sometime within the next 30 days. And the judge will make the determination of what I just told you before as to whether you're the proper person named and whether these charges are adequate, or you can waive that hearing and force Utah to come and pick you up. And so they generally, the clock starts if you were to waive the hearing, the clock would start running today. And they would generally have 30 days to come get you, but they could then request an additional 30 days as an extension. And if that extension were granted, you would be here an additional 30 days. But at the end of the time period, if they have not come and gotten you or picked you up, then the sheriff's department here would release you. Now, that doesn't mean that the warrant goes away. The warrant would still be pending. And if you were stopped 5 minutes later, you'd probably be arrested again because of the warrant. So you would really need to get a lawyer to deal with whatever charges are pending out there. Do you have any questions about this process?
Yes. So if I waive the right to that hearing, how quickly can I expect someone from Utah to come and get me? And the other question is, has the Utah County Court been apprised of my arrest here?
Yes. Before you go through this process, the personnel at the sheriff's department would have contacted them and said, hey, we picked up Mr. Hunsaker, and he is showing that he has a warrant pending. Do you want to come and get him? And they obviously said yes. Now, just because they said yes doesn't mean they're coming to get you. Like I told the other gentleman, I've been a defense lawyer a long time, and I've seen situations where they said yes, but they didn't come and get the client, and then the person was released. But most of the time when they say yes, they mean yes, and they intend to come and get you.
What's the time frame? If I waive that hearing, how much time do they have to come and get me before I'm released here?
The maximum that you would be looking at would be 60 days.
Even if I waive?
Yes, if you waive, that's what you're looking at. If you did not waive, you would have a hearing within 30 days, and then the clock would begin to run at the time of that hearing date.
Okay, so really
So what I generally tell people is that if you know or have a reasonable idea that you are the person named in the warrant and that the warrant is out there, that having the hearing kind of just extends your time. But if you had a plan in place and you knew that they were going to kind of lift the conditions out in Utah County, I've had clients also who they knew pretty much that the condition was going to get lifted. And so they would request to have the hearing so that they could stay. And during that time, the lawyer out in Utah County is negotiating with them, and they reach an agreement as to the client showing up. And it saves them money because they don't have to pay somebody to come out here and get you. And it saves you from sitting in jail with the promise that you're going to show up.
My apologies. This is if I do not waive the hearing. This scenario you described is if I do not waive or if I do waive.
That's if you do not waive. But generally, you have to have that already in the works so that you have a better understanding of what is going to take place. Because if you say, I'm not going to waive because my hope is that my lawyer is going to negotiate something out in Utah County, and then the lawyer is unsuccessful, then you just added more time to your sitting here.
Okay. Rather than waiting 30 plus days for someone from Utah to come and detain me or return me to Utah, how can I arrange to get to Utah in a quicker manner?
So you can sort of do both. You can waive the hearing, knowing that it's going to take them some time to come and get you, but then you have your lawyer out there working to get them to agree to lift the hold. Because because you don't have any charges pending here, so they contact the sheriff's department here and say, release Mr. Hunsaker, you're getting released that day.
And they'll say, release Mr. Hunsaker under, as soon as there's something that's been negotiated for a hearing in Utah.
Right. If your lawyer has worked that out in Utah County, they will have that worked out, and you'll have the added benefit of, like I said, if you're released 5 minutes, if they don't come and get you in release 5 minutes, the warrant is still valid. But if you work something out in the same scenario, 5 minutes later, you're stopped. They will contact Utah County and they'll say, "Oh no, we're not gonna extradite him," and then they'll let you go.
So I guess I just need to get someone negotiating with them right away in order to perhaps have Utah County allow for me to post bail there. Is that a possibility?
Yes.
Even if I'm present here, can I post bail there if that's negotiated?
Yes, because you're being held under an interstate compact that all states have kind of signed on to, as sort of we're going to all work together on this issue. So Clayton County has no interest other than providing adhering to the provisions of the interstate compact, because we would want the state of Utah, if there's someone that we wanted to be returned, we would want the state of Utah to with our request.
That makes sense. So in your experience, do you think it is likely that if I had my attorney negotiate with them, that they could come to a resolution quicker than the 30-day period in order for me to post some bail amount there while incarcerated here, while being held here?
The answer to that question is always changing. So you're charged with larceny, which is not like murder. And so from Utah's perspective, it may be a better use of public funds to allow you to post a bond and get released than for them to pay for a plane ticket, or 2 plane tickets or 3 plane tickets for 2 detectives or whoever to come out and pick you up and to fly you back out there.
Right. That makes sense. Okay, thank you very much.
No problem. So do you know if you want to waive or do you want to have the hearing that I described before?
I'd like to waive the hearing.
Okay, so the deputies there, they will have waiver forms for you to sign. And then they will send those forms to me and I'll sign them and I'll send them back over to the sheriff's department. And they'll notify Utah and your clock will begin running today. But I would strongly encourage you to hire a lawyer as quickly as possible to work on your behalf out in Utah.
Okay, thank you very much.
You're welcome. You're free to go back.
All right, Your Honor, that's it.
Okay, you have a good day.
Yes, sir, you as well. Yes, sir, you have a good day.